reasonable in this case, because the first tier, or the second tier, the first tier is the warrant that the detective presents to the magistrate judge, and they get the warrant. The second tier is when that warrant is tested by a magistrate court judge at a probable cause hearing. So that evidence was tested. This was not a dismissal because the detective didn't show up or a witness didn't show. So this was not a default dismissal. This was a testing of the evidence. And when that evidence was tested, Your Honor.
Okay, you told me that already.
Okay.
So let's move on to something else.
So, Judge, I'm asking this court respectfully to put a bond in place of $75,000 with an ankle monitor that Mr. Huey can pay for himself, with conditions that he have no contact with any alleged co-defendants, with a 24-hour house arrest scenario, and that he be allowed to come to court and to meet with his attorneys. We are asking the court to set a bond based upon the conditions that we put forth, based upon the information that we have presented to the court, and for any other reasonable conditions that the court believes are fair and appropriate under the circumstances. Thank you, Your Honor.
Okay.
Mr. Act, I'm sorry, it's really distracting when you're talking.
Mr. Gary.
Yes, Judge. Judges. As the saying goes, now the rest of the story. What counts?
You're old enough to know who Paul Harvey is, though.
So you do what I do.
Okay, all right.
Respectfully.
All right.
One thing counsel didn't say, but he implied, was there was a grand jury warrant. So what that meant is the case that was dismissed was presented to a grand jury. They did indict Judge Dunaway. Did not have one armed robbery. He had two armed robberies by the same defendant in front of him. That case has been presented to two more grand juries for this case. Both of them found sufficient cause to indict those counts.
But he was on bond already, so I think that's his whole, I think that's Mr. Matthews' point.
I understand. And let me explain, if I can. In Act 76, we have a theft by receiving a firearm. That was not addressed by counsel. In Act 88, we have the armed robbery of Mr. Maynard. Mr. Maynard was struck by a weapon by this defendant. That was the aggravated assault. There was another defendant there. They approached these two defendants. They ran in two different directions. Shots were fired. No one was hit. Mr. Jenkins ran one direction. Mr. Maynard ran another. They took the items from him. He did identify the defendant in a social media. But what he didn't tell you is he also knew who he was. There was a familiarity. It wasn't stranger on stranger. Okay? So that's that armed robbery. Okay? There's also another item where there's another theft. That theft was never reported because it was someone known to the gang. But because it was someone known to the gang, there's a communication between Defendant Williams and Defendant Huey, basically saying if you don't take the property back, you're going to die. That's another robbery. That was not an armed robbery. Make sure close to the court. I'm not aware that there was a weapon used in that yet third one. Then there's the armed robbery of Gary Holloman and Demisha Copeland. Mr. Holloman has recently passed since the indictment for cancer. So we still have witnesses sufficient, Judge. There's also a terroristic threat where he's communicating, when we did a search warrant on his phone, where he's communicating with a young lady we believe to be his female, or at least the mother of his child, where she said she's going to the police over this, what we believe, gang stuff, and he basically told her or responded, if you do, I'll kill you. So we've got that. In his phone, he also admitted to the commission of the crime. Okay? I believe that to be the second armed robbery. So that's also in his phone, since we're talking about evidence at this time, Judge. There's the possession of a weapon by an inmate, which is Act 169. We went and searched their jail cells. Two of the defendants in this case, one being Mr. Huey, had a communication device, a cell phone, in their cell, and a rather large knife, which we refer to as a shank, in their cell. Okay? Your Honor, one thing that's not in the indictment is when they were making the arrest, and what counsel left out, is there was a very large chase where Mr. Huey ran from police officers, ran on the wrong side of the road, ran red lights, ran stop signs. APD finally had to stop the chase because if they didn't, someone was going to get killed. Mr. Huey was not going to go into custody willingly. So with what we have here, he is very clearly and without question a danger to the community. He's already threatened to kill someone, or at least it's in writing that he made the threat. He's admitted, we have evidence that he's admitted to the commission of the armed robbery. So he's out on bond in an armed robbery, commits another one. While
This is
he's out,
heated, y'all.
he enters into a high-speed chase to avoid capture. He threatens to kill someone. When he's in custody, he's got a communication device that's illegal and a weapon. Your Honor, he's a threat to the community and a danger to commit additional felonies. I ask that you deny the bond.
What?
All right.
I think they deserve a bond.
Okay. Based on the state's proffer in this particular situation, the arguments of counsel, both counsels, Mr. Matthews, unfortunately, I am going to deny bond from Mr. Yu at this point in time. Based on what's been proffered thus far, finding a danger to the community, threats to a person's property in the community, and a risk of flight. So, I also find that
Bond denied.
risk to commit additional penalties.
Y'all some dangerous jokers.
For those reasons, I'm going to deny bond at this point in time. However, if the circumstances should change, certainly file an appropriate motion. I'll leave them on with the others for the 9th of January for an expeditious trial. If you have any other motions other than ones you filed, if you would just stay with us just a little bit, I'll see whether or not I can hear the motion to sever at this point in time. But because there's a number of people that have filed that, but let me just see what how our time's going this morning. So unless you have anything else, I
Bond was denied, y'all. Again, these guys are really dangerous to the community out here in the street. They are very dangerous. And while they are in there, they are dangerous to the streets. Woo! So the attorney tried to get the situation down where he can use a monitor and pay for his monitor and use it just to go to to go see his probation house, parole officer, whatever, and it's not working. So the state don't trust them in the street. So it is what it is. You get yourself in a situation, that's what happened. But yeah, this is the young thug and Gunna, and it is 14 other due in court today. I won't be able to record all of them today, but y'all like, share, and subscribe. Do y'all think these guys should get bond, or should they just sit in there until January? Okay. This is your girl, the real deal, Anita Gill. I'm out.